Today, I'm going to talk about my biggest competition as a hot seater. I was just on a 5-week trial here in state court, and there's a lot of things that I now want to make a whole bunch of videos about. So that's all to come based on some of the things that I saw that are happening, not specific to that trial, but things that just kind of came to mind. But there's one thing in particular that I did want to talk about today in terms of kind of getting back into the swing of regular YouTube postings. And that was what I consider to be my biggest competition as someone who makes a living as a hot seater in a courtroom. My biggest competition is not necessarily other hot seaters. And there's certainly competition in that regard. There's lots of people across the country that do exactly what I do, and they're very good at it. I'm not the only one that does it. I'm not necessarily the best person that does it. But the thing that I consider my biggest competition is the lawyer that thinks that, oh, I have a nephew or a son or a niece or an intern that is young and good at computers. And so they might say, for my next trial, I don't need to bring in this expensive trial consultant. I can use that person who's good at computers. And that's exactly what happened on this case. The other side brought in their summer intern, and that person had never taken an evidence class before, and she had never seen a trial before either. This is a firm that litigates a lot of cases, well respected in this city, but had never gone to trial, at least during the summer months, a couple of months each summer while she had been there. As far as I know, I didn't get the full story, so this is kind of my understanding of it too. So I may have some of the details a little bit wrong. If I do, then take it as a hypothetical. But in essence, what you had was someone that was new to trials and kind of trial advocacy, new to trial presentation. She had gotten some training from someone else at the law firm who had learned trial director. And based on the way she was taught, I think she learned trial director. That other person learned trial director probably about 10 years ago. And then you also had an attorney who was not familiar with working with a hot seater. And so I think in that situation, some of the times you might be able to get by with it and it might work okay. But in this trial, it was a 5-week long trial, very complex. Lots of things were changing very quickly. And that's where I feel like the experience really comes into play, and having a little bit of understanding about what's going on in trial becomes also really important as well, which you don't necessarily have to go to law school, have legal training to be able to understand that, but if you don't, experience I think becomes really important. For example, in this case, there were lots of things that were being argued that needed to be redacted or taken out through motions in limine or pretrial motions. And then as we went, certain exhibits, the plaintiff would want to try and publish those. Our side would object. And then the judge would say, you can publish it if you redact different portions. And sometimes it was explained that clearly, but most of the times it wasn't. Most of the times it was, Judge, I'd like to publish Exhibit 17. Defense objects due to motion in limine. Judge says sustained. Plaintiff says, well, we'll redact it. Judge says, okay. And so then the exhibit would go up, but unredacted. And so that person this was her first trial, didn't know by listening what was being talked about. And because the references were basically to motion in limine like 17, she wasn't aware, and I wouldn't have been aware either, even with experience, exactly what they were talking about. I kind of figured it out. But I don't think she knew that she needed to be listening to those discussions, because I think from her perspective, so many of the discussions between the lawyers and the judge in terms of what is or isn't admissible were kind of irrelevant, and either something would go up or it wouldn't. And so that's where I think things became problematic. The relationship then amongst the hot seater and the attorney then seemed to kind of deteriorate over time. And eventually, this trial had a holiday in the middle of it, and over the holiday weekend, it got to the point where that summer intern, it was her second summer interning at that law firm, decided that she wasn't going to come back. And so they had to scramble to find another person to kind of fill in for the rest of the trial. And even then, with someone who was more experienced, it still wasn't great because the communication wasn't really working between the hot seater and the attorney. Ultimately, they made it to the end of the trial fine. There were no mistrials granted. So we made it to verdict, and everyone kind of survived, I guess, on a literal sense. But it was a headache that I don't think most trial attorneys would ever want to have to deal with. And I think it serves as a useful cautionary tale. That's just kind of where I'll leave that there. That is my biggest competition still, even in 2019, is the idea that it's simple enough that any other person who's good at computers, whatever that means, can do it. Let me know if that's something that you guys come across as hot seaters. I know a lot of you guys do either hot seating on the side of other litigation support services, or maybe you're starting out doing hot seating. Let me know how you guys are dealing with it. I'm sure you guys are encountering that as well. Thanks so much for watching and making it to the end of this video, and I will see you guys on the next one.